Hello everyone, my name is Charlotte Nash and I'm going to talk to you today about intellectual property law. And the company I have chosen to discuss is Smart Cups LLC, and the document we're going to be talking about is their trademark application. So the first question you might be asking yourself is, what exactly is intellectual property law? Intellectual property refers to property right that is defined as the intangible personal property. What exactly does intangible mean? Well, intangible personal property refers to a work or invention that is a result of creativity. And IP law helps to protect these creations of the mind. So you don't end up like our friend over here to the right, who's locking up his creative designer every night in the office. Intellectual property law is primarily made up of patents, copyrights, and trademarks. Patents are property rights that allow the inventor to prevent others from making, using, offering for sale, or selling the inventor's creation. And there are three main types of patents. The first is a utility patent, which is granted to anyone who invents or discovers any new and useful process, machine, article of manufacture, or composition of matter, or any new and useful improvement thereof. The second are design patents, which are granted to anyone who invents a new, original, and ornamental design for an article of manufacture. And the third are plant patents, which are granted to anyone who invents or discovers a new and distinct variety of a sexually reproducing plant. Copyrights are property rights granted by a government to the author or creator of an original work. So you can see that this guy has claimed that he has copyrighted a list of excuses that his employees are no longer able to use. However, there are times when copyright law does not apply. The first is public domain, which is when property is no longer protected by IP law, and it allows anyone the ability to copy, make use of, or adapt the work. The second is fair use, which is driven by the First Amendment's right to free speech, which basically states copying of copyrighted material done for a limited and transformative purpose, such as to comment upon, criticize, or parody a copyrighted work, is acceptable and allowed by the law. Importantly for our discussion today are trademarks, which is a property right that protects words, phrases, names, logos, symbols, sounds, or colors that distinguish goods and services from those manufactured or sold by others, and to indicate the source of the goods. Put simply, a trademark usually refers to a brand name. You can see in the image in the middle a couple of examples of some trademarks: Microsoft, Coca-Cola, McDonald's, Nike, KFC, and Apple. And a really funny cartoon to your right features a squire reading out a list of names to a king, and it basically is listing a bunch of different names: Sacramento Kings, LA Kings, Kings of the Road, Burger King, so on and so forth. And the squire is asking, have I left anyone out of your trademark infringement suit, sire? So it appears that the king has trademarked the term king, and he is now going to sue all of the people who used that word without his permission. So you might be wondering a couple of things. The first might be, who is Smart Cups LLC? The next might be, why do they need a trademark application? You might wonder what a trademark application even is. And you might be asking yourself, how do you file a trademark application? We're going to discuss all of those things in the next few slides. Let's begin by talking about who Smart Cup LLC is. So Smart Cups LLC is a beverage manufacturing company that prints any type of beverage on any surface. And they're operated locally here out of Mission Viejo. And the company's goal is to change the beverage industry by eliminating the use of bottles and cans. The cups have the beverage of your choice printed on the bottom of the cup, and all you have to do is add water or the liquid of your choice. Currently, the company is only producing cups that contain printed ingredients for a variety of energy drinks, but they do want to expand. And if you have a keen eye, you'll see up at the top that the company does have a logo with a little R next to the logo. And that indicates that that logo is trademarked. It is registered federally. And although federal registration of a mark is not mandatory, it does have a lot of advantages, which include notice to the public of the registrant's claim of ownership of the mark, legal presumption of ownership nationwide, and an exclusive right to use the mark on or in connection with the goods and services listed in the registration. So for our purposes today, we'll just assume that that mark had not been registered yet, and we will go through the process that they most likely went through of registering their trademark. So what is a trademark application? We've discussed a little bit about it. It's an application that you have to file if you want to federally register. And to register a trademark in the US, you have to register with the US Patent and Trademark Office, which is also known as USPTO. This process is done entirely online using the Trademark Electronic Application System, which is also known as TEAS. There are strict legal requirements for trademarks, and your trademark must meet these requirements before you can register it with the USPTO. So there are going to be a couple of questions you'll want to ask yourself before getting started into the trademark application online. And those are going to be, is your trademark federally registerable? And in order to find that out, you're going to have to search the database that they provide a link to on their website to make sure that there isn't a trademark already out there that is pretty much similar to yours. You also want to make sure that there isn't a claim already on the trademark, so somebody hasn't already trademarked that image. Then you want to ask yourself, can you properly identify your goods and services that you want to link to your trademark? And this is important because if McDonald's stated that their goods and services were carpentry and they registered their trademark M to be for the goods and services of carpentry, then they could really only use that symbol to promote carpentry. And we all know that McDonald's is not a carpentry service. So that is a very important step. And then the third question you're going to want to ask yourself is, can you properly identify the filing basis for your application? So why are you here today filing this application? And what step in your process are you? Are you currently using the mark in business, or are you intending to use the mark in business and haven't done so already? So there, as you can see already, are a lot of complex factors with trademark applications, and that's why a lot of times people say that you should use a trademark attorney, because they will go through and complete the form for your business, then they will file it for you, and it's advisable to hire one so that your application is not rejected, because it's good to keep in mind that trademark applications are not free, and they actually are pretty costly and very time consuming. So one of the first questions you asked yourself was determining which application is right for your business, because there are multiple options. So the important thing to kind of think about is, where are you going to get the most bang for your buck, and which one is going to be applicable to your business. And so you can see through the chart on the left-hand side that the website gives you kind of the pros and cons of each. And as you can see, for the TEAS Plus, it pretty much ticks all the boxes for us, because we are going to be doing a design with our mark, and it's going to include colors. So we're going to want that box to be ticked, as well as all of the other things that are included with the TEAS Plus. And if you look, the TEAS Plus is also the most affordable option. So you might be asking yourself, how does it work? So we're going to dive into the actual application itself. So we are doing the TEAS Plus, and the first page basically gives you a link to a really informative video that I would suggest anyone watch if they're not using the assistance of an attorney. And it also takes you step by step through the process that you're about to go through. So they're giving you a fair warning of what lies ahead, and they're also in bold giving you a warning that once you file your application, the fee is a processing fee and it will not be refunded to you. So at the bottom of that page is the first question, which is an attorney filling this application out? We are not going to be using an attorney. We're just simply going to be filing this out on our own. Number 2 is optional, so you don't need to fill that in if you don't find it applicable. And we don't, so we're going to just press continue and move on to the next portion. So the next portion of the application is going to be the applicant information page. And this is where you're going to tell them who the owner of the mark is, along with other basic information about your company. So the owner of the mark isn't necessarily the person filling out the form at all times, and there could be multiple owners, so you can add an owner down at the bottom. You're going to want to determine how many owners you're going to have filing this application. For us, we're just going to have ourselves filing the application as the rightful owner to our mark, and we're doing business as Smart Cups LLC, and we're obviously a limited liability company. We're operating out of California. We're going to give them our business address, our business phone number, a fax number at which to reach us, and importantly, our email address, because this is how they're going to communicate with us. And then you're going to want to make sure you tick the box that says you authorize them to communicate with you through email. And the last step is to insert your website address. Now the next page is going to be about your mark information, and this is the time when you're going to identify what kind of mark that you are applying for. So there are 3 different types. There's the standard character, which is used when you're not claiming a particular font style, size, or color. And then there's the special form, which is the one we're going to use because our mark includes a design with words, and it is going to be claiming a particular color. And then the third option is for non-visual sound marks. So the next part of the page is going to be where you upload the image that you are going to be claiming as your mark. And then you're going to want to identify any literal element. So that's the part where you put what words are accompanying your image. And then, like we said, we are going to be selecting color as a feature of our mark. And so we're going to describe the colors as light blue and ocean blue. And we'll be sure not to check the box because we are claiming color. The description page continues, and they really want to make sure you're accurately describing everything. And they provide you with some links that are very helpful. Any underlined words that you see throughout the document are hyperlinks that will take you to new pages that will describe what they're kind of looking for in this. So what we've put is an image of a light blue and ocean blue cup with a transparent water drop in the middle, outlined in white, that accompanies the word Smart Cup. And then you'll see that down at the bottom that there's a section for additional statements. And this section is used for people who are applying for a mark that might need an English translation, that maybe they need a consent from an individual who might be identified in the mark for the use of the mark, or maybe they have a claim of prior registration. There are several different reasons why you might tick that box, but we do not need to tick it for our purposes, so we will move on to the next step. So the next step in the process is your basis for filing. And this is a very complicated section of the form that trips up a lot of people. And so you will have to identify your basis for your filing, like I stated, which basically is asking you, are you intending to use this mark or are you already using this mark? And then you're going to want to identify the goods and services for which this mark is going to be linked. And they do provide you a handy-dandy link to the Trademark Manual of Examining Procedures, which can be found on their website. And it basically describes any kind of class that you could select. For ours, we're going to select the class of beverages. And that's also important to note because as you add classes, you will most likely incur additional fees. You also want to check the box that says you understand that you've selected intent to use and that you are selecting the proper filing basis for the class that you are notating above. So for us, because we're using it for sports drinks, we eventually want to use it for non-alcoholic beverages that are carbonated, and because we obviously have water as a major component, we've ticked all of those and that we're intending to use them in relation to our mark. So the next page is going to talk about the fee information, and it's going to give you options on how you can pay. You can pay by credit card, automated deposit to an account, and you can do an electronic funds transfer. Basically, they want you to show them the money. So you'll see under this section that there is a number of classes. We've only used one, which is beverages, and so we're not going to have to pay an additional fee for using other classes. So our fee is going to be just simply that $225 that we originally had signed on for. In the next portion, you're going to do a declaration, and you're going to need to sign. So there are 3 options as well to sign. You can handwrite in pen and ink, or you can email text form to second party for a signature, or you can choose to sign directly. So we're going to choose to sign directly the document. So the declaration page, you're going to acknowledge that you chose the proper basis for filing of your intent. So our intent for this is an intent to use. We are not already using it in commerce, but we do intend to use it in commerce. And then you're going to basically tick all the boxes stating that to the best of your knowledge, you have filled out this form correctly and that you are the legal person who can fill out this form as the owner of the mark. And it's important to note that when you're electronically signing, you're going to have to use the format that they prefer, which is to do a / and then your name and or your initials and then another /. You're also going to want to put in your signatory position. So if your attorney is filling this out, they would put attorney on record. If you're filling this out, and we are as the principal of our LLC, we're going to denote that we're the principal. We're also going to then include our phone number. And then if we had, as we discussed in the previous slides, multiple owners, we would go to the add signatory little box there, and we click on that, and we'd have the other owners of the mark sign as well. The next step is to validate, and you're almost to the finish line now, so the next part is going to be to pay, and we'll discuss a little bit about the final steps of the process in the next couple slides. So once you click validate, you'll come to this page, which is a validation page, and it's basically going to tell you you validated, but you haven't paid, so your form isn't actually submitted. And this is going to give you the opportunity to kind of double check your application before you proceed to the payment and submission page. And just keep in mind that the fee is not refundable, so you are thinking with your wallet now. And you will want to tick the box at the bottom that basically says you've read all of this, you understand, and then you can move on to the next step, which is payment. You're also important to note is you'll see that there's an email acknowledgement, which basically means you're giving them the right to email you correspondence and email you your confirmation. So what happens after you've paid and you've submitted your payment for the application and you're now looking to find out, is my trademark registered? So after you file your trademark, you have to check the registration status on your own. The USPTO requires that the filer check the status through their online database, which is called the Trademark Status and Document Retrieval, otherwise known as TSDR. You can sign up to receive email notifications, as we discussed in the previous slide, for any time a status change is going to occur. And if after you filed, let's say before you have gotten any email correspondence, if you automatically hit payment and you got your confirmation, then you realize, oh no, I want to change it to a different goods and service or something else. You might have made a small error in your spelling. You can email or call the USPTO, and it may be possible for you to submit a proposed correction amendment through the system. Ultimately, they will determine which errors are correctable and which errors will require you to resubmit your trademark application. And yet again, just to drive the point home, if you are required to resubmit, you will have to pay another application fee. So overall in this project, what I learned is that it might benefit most people to go ahead and utilize a trademark attorney for their expertise. But if you do want to go it alone and register your trademark on your own, the USPTO does have excellent resources available on their website for people to use that are trying to maybe limit their cost as far as when they're doing their trademark application. So I hope you found this presentation informational and that in the future, should you need to file a trademark application, you feel prepared. Thank you.